There's kids. They had guns on kids.
When I hear these girls screaming or see this family sitting on the ground, some of them in zip ties, I'm flummoxed. It's beyond disconcerting to hear the children's shrill, desperate cries. Especially when you realize what's actually going on here. And you know, I say this after it was decided recently that charges would not be brought against the officers because they did nothing unlawful. Why not charge the laws, which make something like this legal, and the training instead?
Hilary Golston's Young Politics. This is Hilary Golston.
Two major points to be made here. One, charging officers in lieu of charging the policies that lead to bad outcomes often yields no systemic change. And frankly, there is an argument to be made. It's not only unfair to charge officers for following the law, but they also become the scapegoats for bad policy, while deepening the schism that exists between police and the community. That conclusion is bolstered by what the legal system decided in the aforementioned case. This was legal, but defined by the Attorney General as disturbing, unacceptable, and preventable. Number two, so much of our discussion about policing focuses on good and bad apples, so-called. And that, too, I would argue, is a fallacious approach. Of course, there are quote-unquote bad apples if you define them as officers who have malicious intent and break protocol. If they clearly break police protocol and policy, the law, they're typically held accountable because those officers do end up being charged, and there's no way to prevent law breaking entirely. We know that. But in most cases, the legal system concludes officers acted within the bounds of the law. So focusing on updating and improving policy can prevent otherwise good cops or good apples from doing things that are both legal and reprehensible. That's the issue. Let's start by reviewing what happened here. What about the violation of this family's right to be free from unnecessary government intrusion? To fairly approach this anecdote of unreasonable police behavior, which the district attorney's office, again labeled disturbing, you must first deconstruct why it's designated as such. And remember, again, while we navigate all this, that this was not unlawful. It was legal. It was within the bounds of the law. That means we're all conceding we're okay with unacceptable laws and training if we do nothing. For me, it begins with the premise for the stop, a stolen vehicle. Structurally, police choices here place more value on a vehicle than the developing minds of children as young as 6 years old, held in utter fear with weapons trained on them. If that were not the case, the officers would have at least let the children sit in the police car or come to the painfully obvious conclusion, no one is in imminent danger here. Everyone can wait in the vehicle while we check this thing out. The worst outcome in a wait-and-see scenario is the driver takes off. Not the outcome that anyone wants, of course, but it's infinitely the more reasonable risk when weighed against the trauma done to the innocents we see in that video. Asked another way, should the value of recovering a stolen motorcycle, which, as you can see, this clearly isn't, trump the rights of the innocent? If the assumption is police protect and serve on behalf of a victim, in this case, the victim would be the person whose car is believed to be stolen. Ask yourself, if your car was stolen and police conducted a stop that might recover it, would you want the family and the minors in the car treated this way in pursuit of returning your vehicle? The answer for me? An emphatic no, of course not. Even if one or more of the adults in the vehicle was connected to the theft, which, very important to note, was not the case here. These folks were just in the wrong place at the wrong time, which makes my emphatic no even more vehement. No, if the car's not recovered, I'm okay with that, considering what they had to do or felt they had to do here. If you're not familiar with this case, it comes out of Aurora, Colorado. In August, Brittney Gilliam was taking her daughter, young sister, and nieces to get their nails done. It was pretty much a girls' trip. Police mistakenly identified her license plate as belonging to a motorcycle that had been stolen. Here again is the vehicle this mom and the 4 girls, 6 to 17, were riding in. A quick 15-minute check of the vehicle description would have yielded a much different result. Local media reports confirm police did not check the information that they'd gotten from a license plate reader, clearly showing them they were looking for a stolen motorcycle with Montana plates, not an SUV with Colorado plates. The SUV clearly is not the out-of-state motorcycle investigators were after. Gilliam and the children were ordered out of that vehicle at gunpoint and frisked. They were forced to lie on the ground. Some of them were zip-tied. They were eventually released once police realized their mistake and officers apologized, but not before. Is this really an acceptable investigatory tool used by police, not for tracking down a killer or a rapist or a terrorist, but for retrieving stolen property? According to the top cop in the department, the interim police chief in Aurora, it is. She said the officers involved had followed the department's high-risk stop protocol, which involves drawing their weapons and ordering all occupants to exit the car and lie prone on the ground. Apparently, even a very threatening, unarmed 6-year-old girl. As I mentioned, within the last few weeks, the district attorney's office of the 18th Judicial District decided the officers didn't break any laws. They did not act, quote, unlawfully. There it is. That is the central issue. Not that the officers were not charged. That's not the issue. The decision not to bring charges actually, while still a critically serious concern, is the much more minor issue. The greater issue is this behavior is lawful. This behavior is within the bounds of the training officers receive in this department, and one must presume other departments. It's lawful policing that, as I said, the DA's office even went so far as calling disturbing, unacceptable, and preventable. That means we can prevent this from happening, and we cannot accept it. Do we want unacceptable investigatory tools to be lawful? I think most of us would say no. Too often these incidents are addressed through case-by-case punitive redress and relief, civil court proceedings, and charging or not charging the officers. I won't diminish how important those avenues can be, especially when civil lawsuits force the department in question to reevaluate or change bad policies. But more often than not, focusing on the officers and lawsuits creates a string of retrospective injury examinations. Justice is a nebulous concept. Really it is. Think about it. The family involved here probably wants compensation for the damages they incurred, mentally, perhaps physically, and that's their right and entirely appropriate and justified. They have now sued the Aurora Police Department, but that is a microscopic view of justice. And the case of Elijah McClain proves that. McClain was placed in a chokehold by police in this same department and ultimately died. The police chief admitted McClain should be alive today. A more than 150-page report released by the city found officers had no legally justified reason to stop him, frisk him, or use multiple chokeholds on this young man, and found that investigators even went so far as working to cover up what had happened. McClain was killed in August of 2019. McClain's family also sued the city and police department. Clearly, the department still has some serious problems, and that micro approach to justice could not prevent this. Effort towards overall reform, however, produces a macro justice for all of us as Americans, so we can commute to our various appointments, work, school, trips, to get our hair cut or nails done without fear. The calls to defund the police are often translated by more moderate voices into restructure policing. I wholeheartedly believe most officers want to do the right thing. They want to protect and serve. It's a hard job. And frankly, it has to be disturbing sometimes. Stopping someone from shooting a civilian or another officer with the use of force is disturbing. It's disturbing to look at, even when it is absolutely the right call. But too often, training in the aforementioned situations appears to prevent bad or good cops from shepherding a just outcome. The bad apple theory isn't sufficient for explaining or preventing cases like these. Troubling police anecdotes need to stop being about good and bad cops, because too often, the codified culture they're policing in bolsters legal vigilantism, and pursuing the resolution of a complaint or crime or alleged crime at the expense of due process or habeas corpus statutes. An element of this debate not often considered beyond how the individual officers behaved in circumstances that, again, are labeled unacceptable is, would most officers, when confronted with the same scenario, do something similar or perhaps follow the same kind of protocol? If the answer is yes, the bad apple theory and the charge the officer solution is not the answer. The bad apple theory only holds up if most lawmen and women behaving in an unacceptable manner are found to be acting unlawfully. And we know that's often not the case. Demonizing officers for following policies accomplishes nothing but multitudinous calls for change and justice, greater derision, while sidelining potential allies in reform who get trapped in a fallaciously created dichotomy between law and order and moral justice. They should not have to choose. Law and order and moral justice are symbiotes. If policies, if laws are indeed ordered, moral, just, and fair. A bad system will produce bad outcomes no matter who the actors are. Can't we all agree training peace officers to unload young girls from a vehicle, place them in restraints, and draw guns on them to investigate a stolen motorcycle isn't just bad policing, it's bad policy and unjust criminal justice? Can't we agree police should be trained to understand the nuances of balancing the severity of the alleged crime with the irreparable harm they can cause in trying to address it? Put more simply, ask yourself, would you want your daughter or granddaughter or niece treated this way in pursuit of investigators' stated objective? I think most of us would say no. Republicans and Democrats have put forward their ideas to fix the system. In a later episode, we'll talk Breonna Taylor and George Floyd and the fact many officers buy into the righteousness of their actions because they've been doing what they're taught to do, in part or in whole. Remember, one of the officers who showed up outside Breonna Taylor's Louisville apartment before that deadly encounter wrote, quote, "I know we did the legal, moral, and ethical thing that night." Based on the empirical evidence, was it? We'll take a look at the elements of the case no one is really considering and understanding how a member of law enforcement could come to that conclusion. I'm Hilary Golston, and this is Young Politics.
We're glad you watched. Watch again. This has been Young Politics with Hilary Golston. If you like this show, make sure to subscribe to Hilary's Young Politics channel on YouTube.